My name is Jeffrey Bowling. I'm a student at Liberty University. This is my presentation for Business 343 for my final presentation project. I will be talking about case number 6 involving Mr. Arnett and the work requirements for holiday pay. Next slide. The role that I will be taking on will be the role of the Human Resources Director. My responsibilities are to manage the relationship between the local union and Saga Foods, who I represent as a Human Resource Manager. The case that we're talking about involves an employee by the name of Mr. John Arnett. He has filed a grievance with the local union, the Teamsters there, due to his company refusing to pay him for a holiday that he thought he was entitled to be paid for. But the collective bargaining agreement had some articles in there that stated that an employee is entitled to sick days, the employee is entitled to holiday pay, as long as certain stipulations are met. Now, Mr. Arnett did not meet these stipulations, and I will go into more detail about that as we move along into this presentation. Next slide. Alright, so a description of the case. Basically, Mr. John Arnett, who is a truck driver, usually works Tuesdays through Friday every week, a 40-hour work week, and he doesn't work on Mondays. Well, this particular year, Labor Day happened to fall on a Monday. So Mr. Arnett was already off on Monday, so he decided to take his holiday on Tuesday, which he would have been paid for. But on Tuesday evening, Mr. Arnett called in sick and said he would not be there on Wednesday. So what Saga Foods did is decided not to pay Mr. Arnett for the holiday, being that he took that sick day and was never really authorized that sick day. The Teamsters Local 444 is going to argue that Mr. Arnett is entitled to his holiday pay because he did call in sick and that he was within the parameters of the collective bargaining agreement. Next slide. The description of the positions on the issues is my position is that Mr. Arnett is not entitled to holiday pay, being that he was not in the parameters and he did violate the collective bargaining agreement when it comes to Article 7 and Article 23, where it talks about holiday pay and sick pay, or sick days rather. Saga Food Services has made the correct decision by choosing not to pay Mr. Arnett, being that he did not meet the standards required in the collective bargaining agreement. Local 444 has no basis to file the grievance, but being that they're the union, they're going to do what they're supposed to do and try to represent their union members and try to get something taken care of for Mr. Arnett. Alright, so next slide we're going to talk about the question that the textbook asks. Assume the role of the Director of Human Resources for Saga Food Services. How would you present your case that John Arnett is not entitled to his holiday pay for Labor Day? Well, the way I thought about it was clearly it states in Article 7 that the employee shall have worked his full scheduled work day immediately before and after holidays except for proven sickness. And that's out of the Bud textbook. Mr. Arnett did not work the day prior or the day after. His day prior he was off, and he took the next holiday, which was the day after, which he was entitled to get paid, but being that he took the following day after that, he was in violation of this article. Article 23 also talks about Mr. Arnett's entitlement to take a sick day. Each employee is entitled to 4 sick days a year, but they cannot be used cumulative, which in my opinion means that it cannot be used 2 sick days back to back, a sick day in conjunction with a holiday, or a sick day in conjunction with a day off. When we come to employer and union negotiations, they need to be very clear and clearly expressed. The contract between Saga Food Services and the local union is written in a very clear language, and it breaks it down fairly easy and clearly on why Mr. Arnett will not be receiving his holiday pay. Next slide. Now, if I worked for the local 444, I would argue that Mr. Arnett did not violate these articles. Since he was scheduled to take that day off anyway, how could they hold him liable because the next day was his holiday day? Therefore, it was going to be cumulative. Now that he called in sick, even though Mr. Arnett didn't speak to the right person, he did call in. Therefore, he would be covered and be allowed and afforded his opportunity to get that holiday pay. Next slide. Question 3. As an arbitrator, how would I rule in this case and why? I would rule, as the arbitrator, that Mr. Arnett is not entitled to the holiday pay because he was in violation of the collective bargaining agreement. He was not doing what was supposed to be happening, and that Saga Food Services has every right to do what they did by not paying him for violating and not being in the legal parameters of the collective bargaining agreement. The language of the contract was very clear. It used keywords to make the intent as clear as possible. His keywords included things as must, should be, will not, certain things that made it very clear to whoever was to read this contract what they were and were not allowed to do in order to receive these benefits. If Mr. Arnett would have received the permission from his manager for sick day, the ruling would most likely be different. If he had proof that said that the manager said, hey, you're good to go, Mr. Arnett, don't worry about coming in tomorrow, take your sick day, then I would have ruled it a lot differently. Next slide. Plan of action. I would advise the local union that the employees who violate these articles will also be denied their holiday pay. I would keep it straight, fair across the board. I would reevaluate the contract to ensure that there's no other language that could be added to make things more clear, just to kind of present or prevent any future arbitrations or anything in that matter. If there was any language added, of course, we would have to renegotiate that contract to get it to where the union and Saga Food Services were in agreement. In conclusion, next slide, Mr. Arnett was not a happy employee due to being denied his holiday pay. He exercised his rights and got the union involved to fight for him. The contract was very clear about the situation, and the union really did not have a leg to stand on when it came to defending Mr. Arnett. It is important that the language of the contract is very clear to prevent as much confusion as possible. No union contract is ever going to be perfect and cover every situation that's going to come up, but we should try to cover everything as much as possible as we can in order to prevent as much arbitration as possible in the future for the company. And this concludes my presentation for Business 343.